Good morning. My name is Marisol Perez. I'm a practicing immigration lawyer here in San Antonio. I'm a partner at DeMott McChesney, Curtright, and Admendaris. I'm also an alumnus here from the law school at St. Mary's. It'll be 20 years this spring. And I also have the great privilege of interacting with the law students frequently at the law school because I teach the immigration survey course at the law school. Today, we have the great honor of having Judge Paul Wickham Schmidt here with us. We are lucky to have him here as he shares his thoughts from his wide-ranging career through many government agencies that have administered our immigration laws. He has served as an advisor, a lawyer, a judge for our government. And in that capacity, it has become very clear that he has worked to develop and transform our agencies for the better over many decades. Judge Schmidt has also worked in the private sector, advocating for a number of immigrants and assisting with various lawyer groups like the American Immigration Lawyers Association, AILA, and other nonprofits that work for justice for immigrants. In the latter part of his career, Judge Schmidt served as board member for the Board of Immigration Appeals, and also, while at the BIA, served as board chairman from 1995 to 2001. Many of us remember his well-thought-out decisions, whether they were presidential or dissenting. And we always thought that Judge Schmidt was a judge who always wanted to do the right thing. In fact, shortly after I started law school, several months prior, Judge Schmidt was instrumental with the decision matter of Kasinga, which really talked about the issues in asylum and refugee law. In my immigration clinic class, which at the time was taught by Lee Teran and Monica Shertman, and now taught by our esteemed Erica Schumer, where asylum law and refugee law is a central focus, I remember us as classmates dissecting and reading and even getting involved in talking about the respondent in matter of Kasinga. And at the time that we read that decision, as students and later lawyers, we had great optimism and hope. And we believed that the judge, Judge Schmidt, and the BIA at the time really laid the groundwork for laws that would protect refugee women. Judge Schmidt left the BIA and returned to the bench as an immigration judge in Arlington, Virginia, and later retired in 2016. Although retired, Judge Schmidt has not gone silent as an advocate. He has a great blog, so check that out. And we appreciate, us as lawyers and advocates, that he uses his longtime knowledge and expertise of all the government agencies and the workings to call attention to the current unraveling of our immigration court system, the unraveling of what we would call justice. He frequently sheds light on the fact that our immigration court system has effectively closed its doors for many folks, and for those folks who get in the door often have no meaningful opportunity to present their case. We also appreciate that this judge, despite his retirement, and who has not remained silent, we're thankful, still encourages advocates like us to not lose hope. Thank you, Judge Schmidt, for your relentless commitment to achieving fairness and justice for immigrants, and please join me in welcoming him to the Scholar Symposium today.
Thank you, Thank you, Marisol, for that very kind introduction. How are you all doing this morning? Yeah, can you all hear me out there? All right. Well, thank you so much for inviting me. And it's really an honor to be here. My job this morning is to take us on into lunch and the main attraction, which will be the Graebner Elementary Mariachi Group. So I guarantee I'll get you there. Today, I'm going to tell you the sad story of how our immigration courts, housed at an agency called the Executive Office for Immigration Review, or EOR, within the U.S. Department of Justice, went from being the jewel in the crown to becoming America's star chambers, where due process and human dignity are trampled daily. I'll intertwine EOR's saga with my own career, because in many ways, my history and EOR's are the same. But there's a larger story in here that I hope you'll pick up and that I hope will tie together much of which we've already heard today. I'll introduce myself to you, tell you a bit about how my life and career have been intertwined with EOR, and then I'm going to briefly address 5 things: the court system's former vision, the judge's role, my judicial philosophy, what needs to be done to reclaim the due process vision of the immigration courts, and how you can get involved. Now, as some of you who might have heard me before know, this is where I used to give my comprehensive disclaimer providing plausible deniability for everybody in the immigration court system if I happen to say anything inconvenient or controversial. But now that I'm retired, we can skip that part. However, I do want to hold the mayor, the scholar, St. Mary's, Gabriel Catt, Dean Johnson, your sponsors, your faculty, you, and anybody else of any importance whatsoever, harmless for my remarks today, which are solely my own views. There'll be no party line, no bureaucratic doublespeak, no sugarcoating, no BS, just the truth, the whole truth, and nothing but the truth as I see and have lived it. And you might be familiar with an old saying, the truth will set you free. But these days, as we're currently observing, the truth can get you fired. Also, because today is Friday, and you are such a great audience, I'm giving you my absolute, unconditional, money-back guarantee that this talk will be completely free from computer-generated slides, PowerPoints, or any other type of distracting modern technology that might interfere with your total comprehension or your listening enjoyment. In other words, I am your PowerPoint. I graduated in 1970 from Lawrence University, a small liberal arts college in Appleton, Wisconsin, where I majored in history. And I found that my broad liberal arts education and the intensive writing and intellectual dialogue involved were the best possible preparation for all that followed. I then attended the University of Wisconsin Law School in Madison, graduating in 1973, so I'm an old guy. Go Badgers. I began my legal career in 1973 as an attorney advisor at the Board of Immigration Appeals, referred to as the BIA, at the U.S. Department of Justice, the DOJ, under the Attorney General's Honors Program. Admittedly, however, the BIA's executive assistant culled my resume from the Honors Program reject pile. At that time, before the creation of EOR, EOR for you Winnie the Pooh fans, the board had only 5 members and 9 staff attorneys as compared to today's cast of thousands. Among other things, I worked on the famous or infamous John Lennon case, which eventually was reversed by the Second Circuit. The chairman of the BIA at that time was a legendary immigration guru, Maurice A. Maury Roberts. And Chairman Roberts took me under his wing and shared his love of immigration law, his focus on sound scholarship, his affinity for clear, effective legal writing, and his humane sense of fairness and justice for the individuals coming before the BIA, a sense, I might add, that is conspicuously absent from today's EOR. In 1976, I moved to the Office of General Counsel at what's known as the Legacy Immigration and Naturalization Service, the INS. There I worked for another legendary figure in immigration law, then General Counsel Sam Bernsen. Now, Sam was a naturalized citizen who began his career as a 17-year-old messenger at Ellis Island and worked his way to the very top of the civil service ranks. And perhaps not incidentally, he was also a good friend of Chairman Maury Roberts. At that time, the Office of General Counsel was also very small, with a staff of only 3 attorneys in addition to the General Counsel and his deputy, another mentor and immigration guru, Ralph Farb. At one time, all 3 of us on the staff sat in the same office. In 1978, Ralph was appointed to the board, and I succeeded him as deputy general counsel. I also served as the acting general counsel for several very lengthy periods during both the Carter and Reagan administrations. Not long after I arrived, the general counsel position became political. The incoming administration encouraged Sam to retire, and he went on to become the name and managing partner of the Washington, D.C. office of the powerhouse immigration boutique, Fragaman, Del Rey, and Bernsen. He was replaced by my good friend and former colleague, David Crossland, who's still an immigration judge in Baltimore, and David selected me as his deputy. Now, Dave also became the acting commissioner of immigration during the second half of the Carter administration, which was one of the periods when I was the acting general counsel. The third general counsel that I served under was one of the most unforgettable characters, the late, great Maurice C. Mike Inman Jr. He was known not always affectionately as Iron Mike, and his management style was something of a cross between the famous coach of the Green Bay Packers, Vince Lombardi, and the fictional mafia chieftain, Don Corleone. Although we were totally different personalities, Mike and I made a good team, and we accomplished amazing things. It was more or less a good cop, bad cop routine, and I'll let you guess who played which role. Among other things, I worked on the Iranian hostage crisis, the Cuban boat lift, the Refugee Act of 1980, the Immigration Reform and Control Act of 86, known as IRCA, the creation of the Office of Immigration Litigation, known as OIL, and establishing what is involved into the modern chief counsel system at the Department of Homeland Security, the DHS. Again, as Ira was reminding me, he told me this morning, I thought you and Inman were bad, but you're nothing. You're angels compared to the guys we have now. So, sometimes you got to be happy with what you have, right? I also worked on the creation of EOR in 1983, which combined the immigration courts, which previously had been part of INS, with the BIA to improve judicial independence. Now, interesting. And I think ironically, the leadership and impetus for getting the judges into a separate organization actually came from Mike and the late Al Nelson, who was then the Commissioner of Immigration. They were prosecutors by position and litigators by trade, but they saw the inherent conflicts and overall undesirability from a due process and credibility standpoint of having immigration enforcement and impartial court adjudication in the same division. I find it disgusting that officials at today's DOJ have actually recreated and aggravated all of the problems and glaring conflicts of interest that EOR originally was created to overcome. Indeed, as I'll discuss later, they've actually weaponized the immigration courts as a tool to enforce their nativist, restrictionist immigration agenda. For example, former Attorney General Jeff Sessions unethically and improperly referred to supposedly fair and impartial immigration judges as in partnership with DHS enforcement. How would you like to have your life in the hands of a court like that? By the time I left in 1987, the General Counsel's office, largely as a result of the enactment of IRCA and the new employer sanctions provisions, had dozens of attorneys organized into divisions and approximately 600 attorneys in the field program, the majority of whom were hired during my tenure. In 1987, I resigned my position with INS and joined Jones Day's DC office, a job that I got largely because of my wife, Kathy, and her old girl network. She's not a lawyer, but she was the president of the cooperative preschool at that time, and that's actually how I got my job at Jones Day. I eventually became a partner specializing in business immigration, multinational executives, and religious workers. Among my major legislative projects on behalf of our clients were the special religious worker provisions added to the law by the Immigration Act of 1990 and special immigrant juvenile provisions of the INA, which some of you in this room may be familiar with. Following my time at Jones Day, I succeeded my former boss and mentor, Sam Bernsen, as a managing partner of the DC office of Fragum, Delray and Bernsen, where I continued to concentrate on business immigration. Immigration, as you can see, is a small community. You always need to be nice to everybody because you keep running into the same folks over and over again as you work your way up and down the career ladder. And while at Fragum, I also assisted AILA, the American Immigration Lawyers Association, on a number of projects and was an asylum advisor to the Lawyers Committee on Human Rights, now known as Human Rights First. One of the AILA projects I worked on, one that I really remember, is I read cover to cover the initial galley draft of Ira Kurzban's comprehensive immigration treatise and made little marginal comments and everything on it. And I don't think there are too many people out there who knew Ira's work better than I did. I'm going to ask you, when he speaks, somebody should ask him how I helped him make his first $1 million when I was general counsel. In 1995, then Attorney General Janet Reno appointed me chairman of the BIA. Now, not surprisingly, the late Janet Reno was my favorite among all the attorneys general I worked under. I felt that she supported me personally, and she supported the concept of an independent judiciary, even though she didn't always agree with our decisions and vice versa. She was the only attorney general who consistently came to our investitures and immigration judge conferences in person and mixed and mingled with the group. She was also hands down the funniest former attorney general to appear on Saturday Night Live, doing her famous Janet Reno dance party routine with Will Ferrell immediately following the end of her lengthy tenure at DOJ. Now, can you imagine Jeff Gonzo Apocalypto Sessions or Billy Barr making appearances on SNL and laughing at themselves? Not likely. They're far too busy demeaning migrants and working every day to destroy due process. Among other things, as chair, I oversaw an expansion of the board from the historical 5 members to more than 20 members, a more open selection system that for a time gave some outside experts a chance to serve as appellate judges on the board, the creation of a supervisory structure for the expanding staff, the establishment of a unified clerk's office to process appeals, implementation of a true judicial format for published opinions. If you ever have to cite a board opinion, and you can go to the advance sheet and actually cite it to the correct page number. That happened because I insisted on it rather than having them all numbered within the decision and then years would go by before they came out in their final pagination. I instituted barcoding. I established a pro bono program to assist unrepresented respondents on appeal. We did the founding of the Virtual Law Library, electronic en banc voting, and e-distribution of decisions to immigration judges and publication of the first ever BIA practice manual, which actually won a plain language award from then Vice President Gore. I also, as Marisol told you, wrote the majority opinion in my favorite case, matter of Kasinga, establishing for the first time that the practice of female genital mutilation, known as FGM, everything has an acronym, FGM, is persecution for asylum purposes. Now, the losing attorney in that case was none other than my good friend, then INS General Counsel David A. Martin, now a famous emeritus immigration professor at University of Virginia Law, who personally argued the case before the board. In reality, however, by nominally losing the case, David actually won the war for both of us, and more important, for the cause of suffering women throughout the world. We really were on the same side in Kasenga, the side of protecting vulnerable women. During my tenure as chairman, then Chief Immigration Judge, now BIA Judge, Michael J. Creppy, and I were founding members of the International Association of Refugee Law Judges, This organization today, headquartered in The Hague, promotes open dialogue and exchange of information among judges from many different countries adjudicating claims under the Geneva Convention on Refugees. Now, to show you how different things were in those days, as chair, I actually encouraged oral argument. We even took the show on the road and once were hosted right here in the moot court room at St. Mary's Law, followed by a great reception featuring, of course, a live mariachi band from a local elementary school. Are any of you guys who were in that band out there today? I mean, you'd all be grown up now, but not that you weren't grown up then. In 2001, under pressure from the incoming Bush administration and new Attorney General John Ashcroft, I stepped down as BIA chairman, but I remained as a board member until April 2003. Then Ashcroft, who was not a big fan of my opinions, invited me to vacate the board and finish my career at the Arlington Immigration Court, where I remained until my retirement at the end of June 2016. So I'm one of the few individuals ever to become an immigration judge without actually applying for the job. Or maybe my opinions, particularly my dissents, were my application and I just didn't realize it at the time. But it turned out to be a great fit, and I truly enjoyed my time in Arlington. I've also taught at George Mason School of Law and at Georgetown Law, where I'm still an adjunct professor. Now, I want you to keep in mind that if everyone agreed with me, my career wouldn't have turned out the way it did. On the other hand, you should remember that if nobody agreed with me, my career wouldn't have turned out the way it did. In bureaucratic terms, I was a survivor. And I've also, at some point in my career, probably been on both sides of most of the important issues in immigration law. As a sitting judge, I always encourage meticulous preparation and advanced consultation with DHS Assistant Chief Counsel to stipulate or otherwise narrow issues. There currently are more than 1 million pending cases in immigration court, a backlog that grows without control every day. Because of this overwhelming caseload, efficiency and focusing on disputed issues in court are particularly critical. Now let's move on to other topics. First, the vision. The EOIR vision once was, quote, through teamwork and innovation, be the world's best administrative tribunals, guaranteeing fairness and due process for all, unquote. And in one of my prior incarnations, I was part of the group that developed that now abandoned and disrespected vision statement. Perhaps not surprisingly, given the timing, that vision echoed the late Janet Reno's equal justice for all theme. Sadly, the immigration court system is moving ever further away from that due process vision. Instead, years of neglect, misunderstanding, mismanagement, and misguided priorities imposed by the U.S. Department of Justice have created judicial chaos with an expanding backlog now exceeding an astounding 1 million cases and no clear plan for resolving them in the foreseeable future. Indeed, former Attorney General Sessions actually maliciously and intentionally added a potential 300,000 previously closed cases that are now aimlessly warehoused, waiting to be added to those already on the active docket. There are now more pending cases in immigration court than in the entire U.S. district court system. And notwithstanding the hiring of hundreds of new judges by this administration, almost all from the ranks of government prosecutors, the backlog continues to grow by leaps and bounds. This administration has added hundreds of thousands of new cases to the immigration court docket, again, without any transparent plan for completing those already pending cases consistent with due process and fairness. They've done this by eliminating the sensible enforcement priorities and prosecutorial discretion established by the last administration. In its place, everything is now a priority, and the flavor of the day is haphazardly advanced before pending cases, which in turn are orbited to the end of the years-long line. This results in what I call aimless docket reshuffling, or ADR Eeyore style. Notably and most troubling, the only things that aren't priorities for this administration our fairness and due process in the immigration hearing process, which have clearly been thrown from the train as the deportation express hurtles down the track. This little but powerful booklet that I hold in my right hand, the U.S. Constitution, has become the enemy in today's weaponized immigration courts. Nobody, and I mean nobody, has been hit harder by this preventable disaster than asylum seekers, particularly scared women and children fleeing for their lives from the northern triangle of Central America. In immigration court, notwithstanding the life or death issues at stake, unlike criminal court, there's no right to an appointed lawyer. Individuals who can't afford a lawyer must rely on practicing lawyers who donate their time or on nonprofit community organizations to find free or low-cost legal representation. Although the government stubbornly resists the notion that all asylum seekers should be represented, studies show that represented asylum seekers are more than 5 times more likely to succeed than those forced to represent themselves. For recently arrived women and children, one study showed that the success differential was an astounding 14 times. An assistant immigration judge for training in the prior administration infamously claimed that he could teach immigration law to unrepresented toddlers appearing in immigration court. And that, as those of you who remember it, that touched off sort of a Twitter and internet storm of people posting pictures of their toddlers, and they'd go through the questions you get in immigration court. I think one of them, they asked a young lady, 3-year-old, what country she'd choose for deportation, and she said pizza. So that's a level of understanding that satisfies due process in our immigration courts. Issues concerning representation of so-called vulnerable populations continue to haunt our court system. Even with clinics and non-governmental organizations pitching in, there simply are not enough free or low-cost lawyers available to handle this overwhelming need. And to make matters worse, as we've heard this morning, this administration has engaged in a number of legally questionable and morally reprehensible gimmicks and schemes to keep asylum applicants at the southern border from even getting to an immigration court. Instead, they're arbitrarily orbited back to Mexico, Guatemala, Honduras, and El Salvador. These are among the world's most dangerous countries without functional asylum systems. Once there, many suffer kidnapping, extortion, rape, torture, and even death at the hands of the same criminal gangs and cartels from which they originally fled. It's a total and very intentional perversion of asylum law and American values. And worst of all, in my view, complicit Article III courts, all the way up to the Supreme Court, regularly tank in their duties to protect asylum seekers' legal and constitutional rights. Instead, they go along to get along or pretend not to see the grotesque human tragedy that they are enabling. Acting Customs and Border Patrol Commissioner Mark Morgan and other administration officials brag about how their actions to wipe out asylum protections have solved the problem and reduced the numbers at our southern border. In their view, refugees seeking legal protections under our laws and international conventions are a problem, and human lives are merely numbers to be reduced. It's part of a concerted effort to dehumanize the other and convert them to non-persons under the law. I call this Dred Scottification, after the infamous pre-Civil War Supreme Court case that declared that blacks were not persons under our Constitution, although I hardly originated that term. But let's take a look behind the numbers and the disingenuous bragging at what our country is really doing to asylum seekers and other migrants at the southern border. Human Rights Watch studied the cases of more than 200 individuals who were returned to El Salvador by this administration. Of these, 138 were killed upon return. Another 70 were subjected to sexual violence, torture, and other harm, usually at the hands of gangs, or went missing following their return. Another human rights study of families sent to Mexico under this administration's disgracefully judicially enabled Remain in Mexico program, I call it Let Them Die in Mexico, found parents said that while waiting in Mexico, they or their children were beaten, harassed, sexually assaulted, or abducted. Some said Mexican police had harassed or extorted money from them. Most said they were constantly fearful and easily identified as targets for violence. A Doctors Without Borders report found that more than 2/3 of the migrants fleeing Central America's Northern Triangle countries, Guatemala, Honduras, and El Salvador, experienced the murder, disappearance, or kidnapping of a relative before their departure. The proud architect of these crimes against humanity is White House advisor and notorious white nationalist Stephen Miller. According to a recent article in The New Yorker, he said he didn't care if El Salvador had a functioning asylum system and that screwing asylum seekers is, quote, all I care about, unquote, in life. This administration has basically blown off these findings by well-respected groups without any evidence to the contrary. In simple terms, in this administration, the lives of brown-skinned migrants coming from south of our border simply don't matter, nor does a constitutional requirement of due process under law. And as I noted earlier, perhaps most outrageously and disgustingly, the Supreme Court and other Article III appellate courts have basically gone along to get along with this administration's abrogation of the rule of law as it applies to migrants. Now, notwithstanding today's legal, constitutional, and human rights disaster, I, for one, still believe in the EOR vision. And later I'm going to share with you some of my ideas for working together to reclaim and reinstitute this noble due process vision. Changing subjects to the role of the immigration judge, what's it like to be an immigration judge? Well, as an immigration judge, I was, of course, an administrative judge. I wasn't part of the Article III judicial branch established under the Constitution. The Attorney General, part of the executive branch, appointed me, and my authority was subject to regulations. We should all be concerned that the U.S. immigration court system is now totally under the control of Attorney General Billy Barr, who has consistently taken a negative view of immigrants, both legal and undocumented, and has failed to recognize the many essential positive contributions that immigrants made to our country. He has also been unfailingly biased against migrants in immigration court and against their attorneys in his negative and unethical precedents. He just issued another one this week. And in his prosecutor-friendly criteria for appointing new immigration judges and appellate judges at the Board of Immigration Appeals. Recently, a group of more than 2,500 former DOJ officials from administrations of both parties, including me and many of my colleagues from the roundtable of former immigration judges, publicly called on Barr to resign for corruption and compromising the independent role of the DOJ. Among other things, we, quote, strongly condemn President Trump's and Attorney General Barr's interference in the fair administration of justice, unquote. The late Judge Terrence T. Evans of the Seventh Circuit Court of Appeals offered one of the best descriptions of what it's like to be an immigration judge. Because 100% of asylum seekers want to stay in the country, but less than 100% are entitled to asylum, an immigration judge must be alert to the fact that some petitioners will embellish their claims to increase their chances of success. On the other hand, an immigration judge must be sensitive to the suffering and fears of petitioners who are genuinely entitled to asylum in this country. A healthy balance of sympathy and skepticism is a job requirement for a good immigration judge. Attaining that balance, is what makes the job of an immigration judge, in my view, excruciatingly difficult. My good friend and colleague, Judge Dana Lee Marks of the San Francisco Immigration Court, a past president of the National Association of Immigration Judges, offered a somewhat pithier description. Quote, immigration judges often feel asylum hearings are like holding death penalty cases in traffic court. An actual practitioner before today's dysfunctional immigration courts was even blunter in an interview appearing in Mother Jones, which next to The Scholar is one of my favorite scholarly publications. He said, an expletive-deleted disaster that is designed to fail, end of quote. Certainly, balance, due process, and fundamental fairness have been sacrificed in today's immigration courts in favor of expediency and weaponizing the immigration courts as tools of DHS enforcement. In other words, they're now structured to be nothing more than a whistle stop on the deportation express as complicit Article 3s look on. Barr has even taken the extreme, unethical, and frivolous step of attempting to, quote, decertify the Immigration Judges Union, the National Association of Immigration Judges, of which, for full disclosure, I am a proud retired member. Now, one of the keys to the immigration judge's job is supposed to be issuing scholarly, practical, well-written opinions in the most difficult cases. That ties directly into the job of the immigration court's judicial law clerks, JLCs assisted by legal interns from local law schools like St. Mary's. Obviously, however, quality and care have now taken a backseat to productivity under this administration's program of dumbing down the immigration courts. Next, I'm going to tell you a few words about my philosophy. And I've heard a lot of this echoed this morning. In all aspects of my career, I've found 5 essential elements for success: fairness, scholarship, timeliness, respect, and teamwork. Now, obviously, fairness to the parties is an essential element of judging. Scholarship in the law is what allows us to fairly apply the rules in particular cases. However, sometimes attempts to be fair or scholarly can be ineffective and less timely. And that's why we should all worry about backlogs that stretch out for 5, 6 years. In some cases, untimeliness can amount to unfairness, no matter how smart or knowledgeable you are. Respect for the parties, the public, colleagues, and appellate courts is necessary for our system to function. And finally, I viewed the whole judging process as a team exercise that involved a coordinated and cooperative effort among judges, respondents, counsel, interpreters, court clerks, security officers, administrators, law clerks, and interns working behind the scenes to get the job done correctly. There are an amazing number of moving parts in the immigration court system, and if any one of them breaks down, it doesn't work. And they break down all the time now. Notwithstanding the different roles, we all should share a common interest in seeing that our justice system works. Our immigration courts are going through an existential crisis that threatens the very foundations of our American justice system. Earlier, I told you about my dismay that the noble due process vision of our immigration courts has been derailed and trashed. What can be done to reestablish it? Well, first and foremost, the immigration courts must return to the focus on due process as the one and only mission. The improper use of our due process court system by political officials to advance enforcement priorities and or to send don't come messages to asylum seekers must end. That's not going to happen under today's DOJ, as proved by over 3 decades of history, particularly recent history. It will take an independent Article I immigration court, which has been supported by groups like the ABA, the FBA, the NAIJ, and others. Indeed, a hearing on the state of judicial independence and due process in U.S. Immigration Court took place recently before the House Subcommittee on Immigration and Citizenship. Our 40-plus strong roundtable of former immigration judges filed a written statement in support of due process and creation of an independent Article I court. And you can find it on my blog, immigrationcourtside.com, which, of course, I highly recommend for anyone trying to understand what's really happening in immigration these days. Clearly, the due process focus was lost even during the last administration, when officials outside EOR forced ill-advised prioritization and attempts to expedite the cases of frightened women and children from the Northern Triangle who required lawyers to gain the protection that most of them needed and deserved. Putting those cases in front of other pending cases was not only unfair to all, but it has helped create what I call aimless docket reshuffling, as I described earlier, that threw the immigration court system into chaos and dramatically increased the backlogs. The Trump administration has greatly expanded the priority targets for removal to include almost anyone who might be subject to removal, even those with long productive residence and no serious crimes. Indeed, one of the greatest travesties is the effort to repeal the so-called DACA program and deport so-called dreamers that is now pending before the Supreme Court. And based on that court's majority's complicit performance and rather pointed ignorance and indifference to both the legal and human consequences of Trump's war on migrants to date, I wouldn't expect the Supremes to come to the aid of dreamers. After all, they aren't their kids. And if you want to hear something really disturbing, listen to the oral argument transcript and hear our Chief Justice ask questions which showed he had no human understanding of what it means to be a dreamer. He doesn't understand what it means to be here and have your work authorization taken away, to be a student and have your scholarship or your authorization to attend school taken away. He asks an inane question, well, you're not ever going to deport these guys anyway, so basically who cares? That's the quality of injustice that we have right now at the highest level of our immigration system. The administration also runs a new and greatly expanded immigration detention empire, situated in remote locations along the southern border, relying largely on discredited for-profit prisons. Many of them are in Texas. I call this the new American gulag, and it's a gross national disgrace of which we should all be ashamed. Here's a recent book just released last week by my colleague, Professor Phil Schrag, who's co-director of the CAL's Immigration Clinic at Georgetown. Baby jails. There's a picture of a baby. This is happening in America, folks. This is a country where we now treat convicted criminals better than we treat migrant babies. The frequent detailing of already overwhelmed immigration judges to the southern border has caused massive resetting of non-detained dockets in their home courts and has added to the mushrooming backlog. Truly, this is ADR in action. The administration also wants to make it more difficult for individuals to even get full immigration hearings on asylum claims and to expand the use of so-called expedited removal, thereby seeking to completely avoid the immigration court process. Evidently, the idea is to remove most of those applying or recently crossing the border to seek protection to notoriously dangerous countries without due process, thereby sending a "don't come, we don't want you" message to asylum seekers. After all, dead refugees stay put. But this administration has gone even further in cutting off access to hearings altogether. They use gimmicks like Remain in Mexico, also known as Let Them Die in Mexico, bogus and fraudulent safe third country agreements with El Salvador, Guatemala, and Honduras, three of the most dangerous countries in the world, all lacking functioning asylum systems, and inappropriate requirements that individuals apply for asylum in the first so-called signatory country they reach. Even more disturbing, Article 3 courts, which should have ended this cruel and inhumane nonsense, have instead enabled it. Additionally, in its all-out war on due process, this administration has basically reduced immigration judges to the status of deportation clerks, with highly inappropriate performance work plans, production quotas, and limitations on their authority to continue or close cases. Second, there must be structural changes so that immigration courts are organized and run like a real court system, not a highly bureaucratic enforcement agency. This means that sitting immigration judges, like in all other court systems, must control their own dockets. The practice of having administrators in Falls Church and political bureaucrats in Washington, D.C., none of whom are sitting judges responsible for daily hearings, manipulate and rearrange local dockets in an attempt to achieve policy goals unrelated to fairness and due process for individuals coming before the immigration courts must end. If there are to be nationwide policies and practices, they should be developed by an immigration judicial conference patterned along the lines of the Federal Judicial Conference. Third, there must be a new organization, administrative organization to serve the courts, much like the Administrative Office of the U.S. Courts. This office should be subordinate to the Immigration Judicial Council. The administrators should work for the judges rather than the judges working for the administrators and the politicos, like is now the case. Currently, the glacial and badly skewed hiring process, inadequate courtroom space planning, poor acquisition, and unreliable, often outdated technology are simply not up to the needs of a rapidly expanding court system. This administration has basically institutionalized worst practices. This includes limiting legitimate continuances and placing judges under performance work plans containing demeaning and sophomoric production quotas designed to produce assembly line injustice. In particular, the judicial hiring process going back over the past 19 years has failed to produce the necessary balance, and we talked about balance earlier, because judicial selectees from private sector backgrounds, particularly those with expertise in asylum and refugee law and human rights law, like many of you in this room, have been so few and far between. Indeed, during the last administration, nearly 90% of the judicial appointments were from government backgrounds. In this administration, nearly 100% of recent judicial appointments by Attorney General Barr came from those with prosecutorial or other public sector backgrounds, government sector backgrounds. Fourth, I'd repeal all the so-called Ashcroft and Barr reforms at the BIA and put the BIA back on track to being a real appellate court as the appellate division of a new independent immigration court. A properly constituted and well-functioning appellate division should transparently debate and decide important, potentially controversial issues, publishing dissenting opinions where appropriate. Of course, dissenting opinions have more or less become a thing of the past. All appellate judges should be required to vote and take a public position on all important decisions. The appellate division must also rein in, rather than encourage and enable, those immigration courts with asylum grant rates so incredibly low as to make it clear that the generous dictates of the Supreme Court in Cardozo-Fonseca and the BIA itself in a case called Mogherabi are not being followed. Well over a decade has passed since Professors Andy Schoenholtz, Phil Schrag, and Jaya Ramji Nagalis of Georgetown published their seminal work, Refugee Roulette, documenting the large disparities among immigration judges in asylum grant rates. The BIA, the only body that can effectively establish and enforce due process within the immigration court system, has not adequately addressed this situation. Indeed, some of the most recent bar appointments to the BIA are immigration judges who deny asylum nearly 100% of the time and are subject to complaints from the private bar and NGOs about bias, rudeness, and other unprofessional behavior. In other words, Barr is intentionally implementing worst practices and policies at the BIA and in the immigration courts in an attempt to snuff out any remnant of fundamental fairness and due process for migrants. He and Sessions have particularly targeted the most vulnerable asylum seekers and their families for this unfair treatment. Now, to say the least, this is hardly through teamwork and innovation, being the world's best administrative tribunals, guaranteeing fairness and due process for all. The sharp drop-off in immigration court asylum grant rates, once in excess of 50%, now under 30%, is impossible to justify in the light of the generous standard for well-founded fear established by the Supreme Court and the board, the regulatory presumption of future fear arising out of past persecution that applies in many cases, and the simple fact that, as we all know, there has been no worldwide diminution in the conditions causing refugees to flee. Indeed, they've gotten worse in many cases. Over the past 19 years, The BIA's inability or unwillingness to aggressively stand up for the due process rights of asylum seekers and to enforce the fair and generous standards required by American law have robbed our immigration court system of credibility and public support. And more importantly, it's ruined the lives of many who were denied protection that should have been granted. We need an appellate division that functions like a federal appellate court and whose overriding mission is to ensure that the due process of the immigration vision of the immigration courts becomes a reality rather than a cruel, intentionally unfulfilled promise. Fifth and finally, immigration courts need e-filing now. Without it, the courts are condemned to files in the aisles, misplaced filings, lost exhibits, and exorbitant courier charges. You could run a state-of-the-art, I guarantee you could run a state-of-the-art e-filing system for the amount of money that EOR gives to FedEx, UPS, and other couriers each year to shuffle this stuff around. Also, because of the absence of e-filing, the public receives a level of service disturbingly below that of many other major court systems. That gives the immigration courts an amateur night at the Bijou aura, totally inconsistent with the dignity of the process and the critical importance of the mission. Yet, after 2 decades of largely wasted effort, EOR has failed to produce and implement such a system on a nationwide basis. Now, keep these thoughts in mind. Of course, Billy Barr and his toadies do not want due process reforms or an independent U.S. immigration court, even though it clearly would be in everyone's best interest, including, actually, DHS enforcement. It's naturally easier to carry out a regime of cruelty and unfair behavior directed at vulnerable migrants when the judges who are supposed to be preventing it are a wholly owned subsidiary of the oppressors. However, eventually our opportunity will come, and when it does, those of us who believe in the primary importance of constitutional due process must be ready with concrete reforms. So do we abandon all hope? Well, no, of course not, because there are hundreds of dedicated and courageous lawyers out there who are former JLCs, interns, former students, and those of you who've practiced before the immigration courts. You form the new due process army, and all of you can be members, and I hope you will. You form the nucleus of what I call the new due process army, and while my time on the battlefield is winding down, yours is just beginning. You will keep at the fight for years, decades, generations, whatever it takes to force the U.S. immigration judicial system to live up to its unfulfilled constitutional promise of guaranteeing fairness and due process for all. Well, what can you do to get involved now? The overriding due process need, and we've heard about this morning, is for competent representation of individuals claiming asylum and or facing removal from the United States. Currently, as I've mentioned, there are not enough pro bono lawyers to ensure that everyone in immigration court gets represented. And the situation's getting worse, with the administration's threatened, if now temporarily blocked by the courts, expansion of so-called expedited removal and other anti-immigrant gimmicks. Lawyers are needed at earlier points in the process simply to ensure that those with defenses or plausible claims for relief even get into the immigration court process rather than being summarily removed with little or, if any, recourse. Additionally, given the pressure that administration is now systematically exerting through the Department of Justice to move cases quickly through the immigration court with little regard for due process and fundamental fairness, resort to the Article 3 courts to require fair proceedings and an unbiased application of the laws becomes even more essential. Litigation in U.S. district and appellate courts has sometimes turned out to be effective in forcing systemic change. However, these days, the Supremes often undo lower court decisions protecting migrants' rights, thereby encouraging even greater and more cruel abuses by this administration in the future. Justice Sotomayor said it bluntly in a very notable dissent very recently from her GOP colleague's decision empowering Trump yet again in an immigration case. Justice Sotomayor said, quote, "The court's recent behavior on stay applications has benefited one litigant over all others," end of quote. That litigant is, of course, the Trump administration. And I'll tell you that virtually no unrepresented individual is going to be capable of getting to the Court of Appeals, let alone the Supreme Court, without getting some representation, and certainly no chance of prevailing on a claim. I've also been working with groups looking for ways to expand what's known as the Accredited Representative Program, which allows properly trained and certified individuals who are not yet lawyers to handle cases before DHS and the immigration courts, while working for certain nonprofit community organizations on either a staff or volunteer basis. This is a critically important program for potentially expanding immigration and representation in immigration court. The Accredited Representative Program is also an outstanding opportunity for retired individuals, like professors who are not lawyers, to qualify to provide pro bono representation in immigration court to needy migrants through properly recognized religious and community organizations. Those of you with language and teaching skills can help out in English language learning programs for migrants. I've observed from my years in immigration court firsthand that the better that individuals understand the language and culture of the U.S., the more successful they are in navigating our immigration court system and both assisting and, where necessary, challenging their representatives to perform at the highest level. In other words, they're in a better position to become informed consumers of legal services. Another critical area for focus is funding of nonprofit, community-based organizations and religious groups that assist migrants for little or no charge. And we heard about some of those wonderful groups today. Never has the need for such services been greater. But many of these organizations receive at least some government funding for outreach efforts. We've already seen how this administration has defunded some outreach efforts and used the money instead for a program to assist victims of crimes committed by undocumented individuals. Now, as I was walking in, I noted out there a table for the U.S. Catholic Conference. Any of you guys familiar with the U.S. Catholic Conference? Yes? Yeah. Is it a great organization? Yeah, okay. I've worked with the Catholic Conference for years. They provided representation in Arlington and at the board for countless individuals. Well, incredibly, yet tragically, the Washington Post reported that Barr overruled his own career staff and took a migrants assistance contract away from the highly respected and exceptionally well-qualified U.S. Catholic Conference, and instead awarded it to a previously unknown group called Hookers for Jesus, run by Christian conservatives. Now, as the Post, Dana Milbank said perhaps somewhat tongue-in-cheek, quote, "There's never been a better time to be a hooker for Jesus," unquote. Undoubtedly, with the huge emphasis on military expansion, unneeded walls, and immigration enforcement, to the exclusion of other important programs, virtually all forms of funding for outreach efforts to migrants are likely to disappear in the very near future. Those who care about helping others will have to make up the deficit. So at giving time, remember your community nonprofit organizations that are assisting foreign nationals. Now, another reason for supporting nonprofit pro-due process groups is the absolute necessity of continuing to litigate aggressively confront Article 3 life-tenured judges with their own complicity in the destruction of our cherished justice system. Constantly confront complicit courts for change, the 5 C's, as I call them. A late great American named Dr. Martin Luther King Jr. once said, quote, "Injustice anywhere is injustice everywhere, is a threat to injustice everywhere." I got Reverend King's message, you got it, but 5 justices of the Supremes and a whole lot of life-tenured Article 3 U.S. Court of Appeals judges unfortunately didn't get it. They keep rolling over and sacrificing migrants' rights, ultimately everyone's rights of due process, protection by the rule of law, and human dignity to our lawless, would-be authoritarian regime and its sycophantic minions. Finally, and most important, as an informed voter and participant in our political process, you can advance the cause of immigration reform and due process. For the last 2 decades, politicians of both parties have largely stood by and watched the unfolding due process disaster in the U.S. immigration courts without doing anything about it, and in some cases actually making it worse. The immigration courts can and must be fixed sooner rather than later, regardless of what happens with overall immigration reform. It's time to let your senators and representatives know that we need due process reforms in the immigration court as one of our highest national priorities. And if they don't listen to you, vote them out of office. End the nonsense. Folks, the U.S. immigration court system is on the verge of collapse, and there's every reason to believe that the cruel, inhumane, and misguided enforce and detain to the max policies being pursued by this administration and disgracefully enabled by life-tenured Article III judges will drive the immigration courts over the edge. When that happens, a large chunk of the American justice system and the due process guarantees that make America great and different from the rest of the world will go down with it. And I know what I'm talking about. I spent most of my professional career dealing with the human wreckage coming for countries, authoritarian countries, where due process didn't exist. In conclusion, in the process of describing my career, I've introduced you to one of America's largest and most important, yet least understood and appreciated court systems, the U.S. Immigration Court. I've shared with you that court's once noble due process vision and how it has been viciously and cruelly trampled to advance a xenophobic, white nationalist, restrictionist agenda. I've also shared with you my ideas for effective court reform that would restore and elevate the due process vision and how you can become involved in improving the process. My friends, both our immigration courts and our democratic republic are in a grave existential crisis. There are powerful and well-organized forces with a very dark, exclusive vision of America's future, one that reverses generations of human progress and knowledge and actively promotes intolerance, misinformation, dehumanization, and deconstruction of our cherished constitutional institutions and fundamental human values. It's an intentionally whitewashed vision of American history, one that denies the ingenuity, creativity, and forced labor of African Americans who actually built our country, disregards the courage, tenacity, and strength of Asian Americans who built our transcontinental railroad and literally brought our country together. And of course, it dismisses the legions of Hispanics who've been making America great for centuries, since before America was America, with their culture, labor, determination, and commitment to the real American dream, not the whitewashed version. The future envisioned by those dark forces X's out many of you in this room, perhaps the majority. Don't let their darkness and willful ignorance be your future and the future of generations to come. Look around you here at the real history and the real America represented by our audience. The future is yours. Don't let the forces of darkness and a past that never was deny your destiny. Now is the time to take a stand for due process, fundamental fairness, human rights, human dignity, and human decency. Join the new due process army and fight to make equal justice under law and the constitutional and human rights of everyone a reality rather than an unfulfilled promise. Due process forever. Thank you. Thank you.
The scholar would like to award Judge Schmidt with a scholar plaque for his presentation. Thank you very much, Judge. Thank you.